Let's dive in. Hello, everyone. Welcome to the first in our Own Your Sound series, winning in mastering the music business. This webinar series is being presented in partnership with the Colorado Music Industry Alliance and Colorado Attorneys for the Arts, which is a program of the CBCA. This is our first in a series of 6 webinars, and tonight's really giving us the foundational understanding of copyright, understanding your copyright, understanding some of those key contracts and how music flows, how money flows through there in the music industry. I'm Meredith Sadler. I'm the Deputy Director at the CBCA and the Administrator of Colorado Attorneys for the Arts. And just a few housekeeping items to get us started, if I can find, oh, there we go. So for tonight, we ask that you stay on mute, and we also invite you to keep your camera off. That helps have everybody stay focused, pay attention to our wonderful presenter and the content that he is going to provide us tonight. We are also recording tonight's webinar. So if you're watching this later on, hello to you. All of the webinars in this 6-part series will be recorded and available afterwards. So you can catch up if you missed one, if you want to go back and see it again. But I also want folks to know that, again, we'll be recording this, so keep that in mind. Introduce yourself in the chat. Let us know who you are, where you're coming from, maybe what your role is in the music industry, and also use that chat to ask questions. For the most part, we're going to save questions until the end of the presentation. So if they come up, feel free to add them there. We'll capture them. If not, we'll make sure you ask them at the end. And we just ask you to be respectful to our community here online, for those joining us live, and make this a great space for us all to learn and share together. And there's this is a 6-part series, so if you did not sign up for all of them, you can sign up for some. We're going to be talking about publishing and licensing and business formation and lots of different areas of running your music business. So just to I want to invite my co-presenter, DNA Picasso with the Colorado Music Industry Alliance, just to give a quick overview of what this wonderful organization is. So yeah, DNA, can you share a little bit more about CMIA?
Yeah, of course. What's up, everyone? Thank you, Meredith. For those who don't know me, I'm DNA Picasso. I'm a songwriter and recording artist out here in Colorado, and the co-founder of the Colorado Music Industry Alliance, a new music organization aiming to unite musicians, artists, venues, radio stations, and other music communities, all working towards raising the profile of Colorado's music scene. And we're trying to do that through programming, educational programming, development, community building, networking opportunities, etc. So I'm gonna keep it quick. Please, if you don't already know about it, please visit Colorado Music Industry Alliance website at comusicindustryalliance.org. And there you can find all of our events like these ones, all posted in our calendar. You can sign up for these mostly free events, and just be engaged. A lot of people ask how they can be involved. I think showing up, doing exactly what you're doing right now is exactly what needs to be done. And if you know anybody who can benefit from these programs, please share it. But yeah, I appreciate you all for being here. Thank you, Meredith. Thank you, Max, for being here and presenting this today. Yeah, I'm excited, and I'm also a student. I got my notebook, so I'm locked. I'm locked in.
We are all here to learn. Thank you. We'll throw those links in the chat as well for, again, folks joining us live. And just a quick commercial for Colorado Attorneys for the Arts. This is just a taste of what we do at CAFTA, which is all about providing legal services and legal education to artists and creatives across the state. One of the key ways we do that is actually a referral service to connect qualified artists to pro bono or free legal assistance. So if after hearing this, you realize, woof, I really need to get a trademark copyrighted. I need someone to review this contract. Someone handed me a contract. Someone broke my contract. CAFTA might be a great resource for that. We also do consultations on a quarterly basis. So we'll put those in the chat. You didn't come here to listen to me. You didn't come here to listen to DNA. You came here to listen to the wonderful Max Haas, who is with his own law firm, a national law firm actually called Holon Law. He is also a musician himself, so has been in your shoes. And we're excited. Today, the first presentation in our series is all about those copyright and contract fundamentals. So get your pens and pencils ready. Max, I'm going to turn it over to you to get your slides up and take it away.
Thanks, Meredith, and thanks everybody for being here. Always nice to see a full audience. I've got my slides up here. Let me get these other windows out of the way. Yeah, so we're here to talk about music copyrights. This is, as Meredith mentioned, part of a 6-week series. So today is sort of laying the foundation for the next 5 weeks that follow. Things that you'll learn in this class today will be really useful next week and the week after when we talk about publishing and masters, and they'll even still come in handy later on when we're talking about contracts, and to some extent business entities as well, that we won't touch on that too much tonight. But it's all really meant to build on the previous week's class. So today will sort of be that initial foundation before we start getting into more specifics and more details in each of the following classes. With that being said, just a brief disclaimer, this is just education. This presentation is not legal advice and should not be interpreted as legal advice. We are able to provide legal advice in situations where we have attorney-client privilege and confidentiality, and that's just not what we have here in the format of a workshop. So if you have questions about your specific situation, please try to either frame them in more general terms, or we will try to respond to them in more general terms, or we can find a separate time to set up a consultation. But just understand that what we're talking about here today is really education and to some extent recommendations for best practices, but not everything will necessarily fit your specific situation. So take some time to think about that and apply it, and work with an attorney if you need, if you've got a specific situation that you need to deal with. So just a little bit about me. I am primarily an entertainment attorney. I work very much in the music and film industries, but I also work with photographers, painters, illustrators, writers, and other creators, really just anybody who has issues that involve that intersection of copyrights and contracts. But I also do quite a bit of business law and trademark as well, because every artist essentially is an entrepreneur. So my practice area spans a couple of different areas of law we'll talk about in the next couple slides. But I'm also still a working musician. You can see I have one of my oldest basses on the wall behind me here, and I play in a couple bands in the Denver area. And I went to law school in New Orleans, where I was involved in the music scene there for several years. So, all that to say that this is where I spend my time. This is what I'm really passionate about. So I'm happy to be able to share this info with you here tonight. So just a brief overview of what we're going to touch on. I've got just kind of an introductory slide coming up next. Then we're going to talk about copyrights. From that, we'll talk about contracts. We'll talk a bit about how copyrights and contracts intersect and some of the issues that come up there. We'll touch on some AI things because those are commonly asked about, and then we'll have time at the end for Q&A. So to that point, we do have a lot to cover tonight, and I find that we're usually answering a lot of questions as we go. Many times questions that come up on one particular slide get answered on the very next slide. So try to save your questions for the end or write them down so we can circle back to them, and we'll definitely have time to discuss in the last 15 to 20 minutes or so. So very briefly, I wanted to include this slide because it comes up quite a bit. I've found in the creative industries, when a lot of people think of an attorney, they usually think of someone who's going to help them out when they get into some sort of trouble. We have a lot of cultural reasons for that between TV shows and lawyer jokes and other things. It's usually what people think of is a litigator, somebody who's involved in lawsuits, who's usually very expensive. Getting out of a lawsuit or getting into a lawsuit is usually a pretty expensive process. But they are necessary because people do get into problems that can't really be resolved without the leverage of litigation. That being said, there is a totally other category of attorney, and that's where entertainment lawyers typically fall into, where we're really here to proactively prevent disputes, help you work out terms of agreements in advance so that you can have clarity and stability in your working relationships. And so we do that through drafting and negotiating contracts, advising you on how best to protect your intellectual property through copyrights, trademarks, and other methods. And again, really trying to prevent disputes from arising in the first place. So this type of lawyer, when you see people hold themselves out as an entertainment lawyer or somebody who can help with contracts, it's actually kind of this whole other approach to doing things. So much of what we'll be talking about today really falls into this category of how to best protect yourself and set yourself up for success. Yes, there are sometimes costs involved, and it's an investment really in growing your business and growing the business around your creations. And that being said, it's usually quite a bit cheaper than having to pay for a litigator later if you get into trouble. So that's all I have to say about that. We're gonna move on from there. So just kind of a high level overview. Intellectual property is an area of law that essentially establishes a form of property rights, and they're intangible property rights. So they don't have the physical manifestation, but intangible property rights in certain types of human creations. And so broadly speaking, there are generally 5 major categories of intellectual property. The 3 that people have probably heard the most about are copyrights, trademarks, and patents. And those are areas of law that have a pretty significant federal component to them, so that they apply basically the same way everywhere in the United States. And every country has their own intellectual property system. It's a set of national rights. So there are a lot of international treaties where countries are cooperating on these things, but generally speaking, these rights apply within a particular country. So in the US, we have a federal copyright system so that all forms of works of creative expression are protected by copyright. And that's what we'll be spending the first chunk of this presentation talking about. But there's also these other areas of law: trademark, which is meant to protect brands, logos, brand names, slogans, things like that, and patent law, which protects inventions. And so while these are sort of commonly in the culture and people talk about them and sometimes use them interchangeably, these are actually distinct areas of law. So they mean different things as terminology and as in terms of the types of legal protection you get from them. And then there's 2 other areas of intellectual property that commonly come up with small businesses, with creative businesses, and especially in the entertainment industry. We have trade secrets and name, image, and likeness rights, also known as your privacy rights, personal privacy rights. And so these intersect with these other areas of law in different ways. Primarily copyright and name, image, and likeness rights often overlap in areas of film and photography. While the photographer owns the copyright, the person in the image holds the privacy rights. Hence my use of this picture of, I believe it's Shia LaBeouf under that paper bag, who is essentially not consenting to his image being used by covering his face. And that's his right to do as the owner of the privacy rights. But the photographer can still certainly take a picture. So slightly related, but a different area of law. So just wanted to kind of help orient you with that slide. So with that being said, let's talk about copyright. So copyright, as I said, first and foremost, is a form of property, which means it can be owned by somebody, it can be bought and sold, it can be rented out, what we call a license. It can even be inherited. So when someone passes away, their copyright is still in effect, and the person who inherits the deceased person's estate will also inherit their copyright. So it's all the same types of things that happen with really any other type of property. And so when we talk about it as a form of property, we're not talking about a physical object that you can hold and that you can sort of label as your own in some way. It's an intangible form of property, and specifically what it is a bundle of rights. And we'll talk in a little bit more detail on the next slide about what those rights are. But as the owner of the copyright, you get to control what happens with that work of creative expression that is protected by copyright. And it's separate from the physical object. So in the sort of most classic example that I typically use when I explain this to people, if you think of a painter painting on a canvas and then selling that work to a gallery or to a collector, they're selling the physical object, but they are not necessarily selling the copyright, because the copyright is a separate, legally distinct form of property. And the person who buys the physical object is not also buying the copyright unless they have specifically negotiated with the copyright owner to do that. So when that collector takes that painting home, they are allowed to hang it in their house, but they are not allowed to exercise any of the rights of copyright, meaning they can't make prints of the image, they can't put it up in a gallery without getting permission from the copyright owner, who is usually the artist in that situation. So in the music world, the example that I use is, having digital files or physical tapes or master sessions or something like that that contains audio files on them, which essentially embody the copyrighted work, does not necessarily give the person who owns that hard drive permission to do something with that music, right? So that's part of why the Napster situation back in 1999 and 2000 was so bad, is because digital files are really easy to copy, super easy for people to send around and share with each other. But just because you can share that object that holds the artwork does not necessarily mean that you actually have the rights to the work itself. So using the copyright actually requires permission of the copyright owner, even if you have a copy of the work in your possession or something like that. So in order for a copyright to exist in the first place, you need to have two things. First, it needs to be an original work of authorship. And the second is that it needs to be fixed in a tangible medium of expression. So when we say original work of authorship, we're not talking about a very high bar here. It just has to have some minimum degree of creativity. It also needs to have a human author, and we'll talk more about that on the AI slides later. And that minimum degree of creativity really just means you can't simply be copying something from someone else, and you can't simply be rehashing facts or just laying out, a raw form of data or something like that. There needs to be some amount of human creativity that goes into the work that's being made. And then and to be clear, copyright does not only apply to art, it applies to all sorts of human creativity. So even, very technical documents that are used internally at businesses, things like that, can also have a copyright. And we'll talk a little bit more about that on the next couple slides. The other component is that the work can't just live in the artist's head. It needs to be fixed in some medium of expression. So if you get an idea for a melody that pops into your head, you don't have a copyright in that until you have actually recorded it or transcribed it and written it down in some way. There needs to be some sort of medium that actually contains an expression of the work. It can be paper, canvas, a digital recording, all sorts of forms of media are permissible here. But the point is that it has to live in some sort of fixed way so that someone else could come along and perceive the work and be able to copy it. Even though they're not allowed to without permission, they need to still have something they'd be able to see and perceive and do something with. So what that also means is that the copyright comes into existence the very moment that you have that fixation. So as soon as you write down the lyrics to your song, you have a copyright in those lyrics. As soon as you get that melody out of your head and into a voice memo on your phone, and believe me, I have a couple on here, then you have a copyright. Okay, so registration is an important thing to be aware of. It's an important thing to consider for your work. It's necessary for litigation if you end up in an infringement situation, and there's other significant benefits that come with that. But contrary to popular belief, your work does not exist in some legal limbo purgatory state until you've gone and registered it. It's not a prerequisite for you actually owning a copyright, but instead you actually have that copyright the moment you fix it, the moment you record it or write it down. Okay, so as long as you have those two elements, you have a copyright. So what you have, and I'm going to skip here for a second because I realize my slides make a little bit more sense in a different order here. But what you have as soon as that work is fixed is this bundle of rights that's shown on the screen here. That intangible bundle of rights that a copyright is this list of rights. And what this means is that you as the copyright owner get to exclude other people from doing any of the things on the bullet point list. It also means that you are the only person allowed to do any of those things. And what flows from that is that if anyone else wants to do something like make copies of your work or distribute copies of your work, whether they made them or they got copies from someone else, or create derivatives based on your work, like a sample or a film based on a book. If they want to do any of those things, they need to get permission from the copyright owner. That's what exclusive rights means, is that only that copyright owner gets to greenlight the exercise of these rights. So these first three are universal. Every type of copyrighted work has these three rights: to the ability to make copies, to distribute copies, and to create or authorize derivative works based on an original work. And then, depending on what type of work it is, there are three additional rights that apply in slightly different ways. So for visual art and other things that are capable of being displayed, there is a right of public display. So visual artists get to hang their work on the galleries because they are usually the owner of the copyright to those works. Sorry. A museum or a gallery does not just arbitrarily decide on its own that it's going to hang certain artworks in their gallery. They have to get permission from the artist or the artist representatives to do that. For the types of things that can be performed, such as songs, plays, movies, other types of performances, choreography, there is a right of public performance. And again, as an exclusive right, what that means is that you get to decide when and how, or if at all, that work is publicly performed. And then the very last one is kind of a weird one, but it's very important in the music industry. There is no general public performance right for sound recordings. And it has to do with a long, complicated political history of the way music was first recorded and made available for the public through radio in the early 1900s. And basically, the Congress has never had the political will to give full copyright to sound recordings. In fact, until the 1970s, copyright didn't even exist at the federal level for sound recordings. So weird history with sound recordings, but the point is that there is not a general public performance right for sound recordings, while there is a public performance right for musical compositions. And that creates a weird situation, especially involving radio play, where songwriters and publishers get paid, but the recording artists and the labels do not, because those are public performances and sound recordings are not entitled to demand royalties for something that doesn't come with one of these exclusive rights. So it's very significant It has major impacts on the music industry and is constantly being debated and fought about in Congress. But in the late 90s, early 2000s, there was finally some change to the law that created a limited public performance right for sound recordings, but only in the context of digital streaming. And even then, the practical way that royalties come in from sound recordings in this very limited form of digital streaming is usually only in the sort of internet and satellite radio, essentially counterparts to AM and FM radio. So it's somewhat significant, but definitely is not a full public performance right the way musical compositions have. So that's pretty important. So real quick, just to take one brief step back to some important terminology, there is a distinction in the copyright world between authors and owners. So authors are the people who create the copyrighted work, the person who is actually making that expression of human creativity. And typically the author is the owner of that copyrighted work. They are the initial owner in most situations. But the owner can be a different person. So the copyright owner can start as the creator, and then that creator can transfer their ownership to another person. If you have multiple people working on something together, and the goal is for them to create one unified work at the end of the process, then the law will generally consider them to be co-authors in a joint work, which makes them automatically co-owners in the corresponding copyright. And this is really important terminology and a distinction to understand because it affects what you can do with copyrights, especially with when contracts get involved later on as we work through this. So I'll just say that for now, and you'll see how this all fits in. So on the left, we have the categories of the types of works of human creative expression that can be protected by copyright in the United States. This is in the US copyright statute. It's also the labels or terminology that you typically see at the US Copyright Office if and when you go to register your work. You'll see that they ask you as the very first question, what type of work you are going to register. So as you can see from this list on the left side of the screen, it's a pretty wide range. And each of these categories is very broad in and of itself. So audiovisual works includes any type of video content, right? Anything where it's a film, a TV show, an episode, a commercial, a music video, lots of different visual moving image type things count as audiovisual works. There's also lots of multimedia works that are generally considered to be part of this category. So video games, interactive experiences, VR experiences, things like that typically would fall into that category. Then you've got dramatic works, which include stage plays, screenplays, things like that. Non-dramatic musical works, and the reason that the copyright law makes this distinction is that generally the music associated with a stage show, like the book for a musical, for example, is considered part of a dramatic work, whereas all of the world of music that is written for things other than musicals is considered just straight up musical works. So they make that distinction. But broadly speaking, these are all types of works of performing arts. So the old school copyright office, when you're using paper forms, would have you using the PA or performing arts form for a musical work because it's in that much broader category. There's also a very, very broad category for literary work. So anything written, books, poems, newspaper articles, magazines, technical writings, instruction manuals, encyclopedias, all sorts of things fall into literary works. Pictorial, graphic, and sculptural is two-dimensional and three-dimensional artwork. Architecture, blueprints, architectural drawings, designs, things like that are protected by copyright. Choreography, which has made really great strides in recent years, getting registration for non-narrative choreography. The Copyright Office used to have a long-standing policy where essentially only ballet was protected, but Beyonce's choreographer, actually was the one who kind of spearheaded a new approach and made some arguments through his attorney that basically got the single ladies choreography registered for copyright and really opened a whole new world of kind of recognizing the broad scope of protectability for choreography. So that's definitely an interesting new category. Well, it's been in the law for a while, but a lot more can be done with it in the future. And then as a separate category is sound recordings. And we'll talk about musical works and sound recordings primarily during this class and the next 5 weeks that follow. So I want to make sure that these are highlighted because these are two separate types of copyright. And this is really important to understand. You're going to be dealing with two forms of copyright pretty consistently in the music industry if you are a songwriter who is also a performer or vice versa, right? So on the right side of the screen is just kind of a more illustrated way to show you the broad scope of things that can be protected. Really, any type of human creative expression falls into this category. So like I said, we're going to be focusing on just two of these: musical compositions, also known as songs, or the publishing in the music industry, and audio recordings of those musical compositions, also known as sound recordings or masters. We'll talk more about that on the next slide here. So you have the song. Sit down and write a song. You have a copyright in that song. And we're talking about the lyrics, the chord progression, the melody, the harmony, the arrangement, things that make up the song that are independent and separable from a recording. You can have a song without a recording, right? You can write down the lyrics. You can write out the sheet music. You can write out a lead sheet. You can explain verbally to someone how the song works and then use a recording as a way of showing what the composition actually is. But it doesn't require there to be a polished studio produced recording in order to exist as a standalone work. And that is why we have, as part of the music industry, these two major categories of the publishing world and the recording world, because they are all built upon these two separate copyrights. So the owners or the authors of a musical composition copyright are typically the people who create the song. So the lyricist, the composer, and this is whether or not they are also the performers on, the authoritative studio recording of this song. In many cases, especially in the pop world and the country world, and even to some extent in the hip hop world, the writers and the performers are not always the same people, right? And so there's two separate copyrights here that track with the activities of each of these different categories of people in the music industry. So on the other side, you take your song and you go into the studio to record it. Now you've created a totally new, separately copyrightable work. Now you have a recording. You have the song over here. You have this particular recording of the song here. You go and play the song live and put out a live album. Now you've got another recording of that song, right? But it's still a separate work. Covers, people make all kinds of cover versions of songs. They all own their own independent recordings, but it all still flows back to one song, right? So in the industry, we call these the masters, right? When you go into a recording session, you come out with your stems, you go mix it, master it, you've got your final polished song that you deliver streaming or put on CD or vinyl or whatever. And now you've got your copyright on the recording side. The authors of a recording are anybody who's making any sounds that you hear in that recording. And just to be clear, you can have a copyrighted sound recording that does not have any music, right? So you can own a copyright in a recording of nature sounds or of people speaking, or you can have a recording of, a speech that someone is making. It does not depend on there being music here, right? Because they're two separate copyrights in our legal system. And so the author is anybody who is actually creating that recorded sound. Typically what that means is instrumentalists, vocalists, producers, to the extent that they are helping shape sound of the recording. And in the pop and hip hop world, frequently producers are also making the instrumental tracks, so they're very much part of the composition as well. But really, anybody who's making those audible sounds is going to be considered an author of that sound recording, and therefore the initial owner of that copyright. They own the masters simply by having participated in recording those sounds and making that recording. Weirdly enough, copyright law excludes engineers from having authorship or recognizable authorship in a recording, but you can always use contracts to still give your engineer a percentage of ownership if you're feeling generous, or at the very least cut them in on some back-end royalties, because ultimately engineers are obviously helping obviously helping shape the sound of a recording, but unfortunately the law just doesn't recognize that. So kind of a weird quirk in the copyright law, but is what it is. So when you've got these two separate types of property involved, there are two very distinct categories of revenue streams. You're going to have to ask mommy for help. Two very distinct categories of revenue streams in the music industry as well. One of them flows from the songs, also known as the publishing, and the other flows from the recordings, also known as the masters. So we're going to get into a lot more detail with each of these over the next couple of weeks. Week 2 will be focused on publishing, and week 3 will be focused on masters. So we're going to really dive in much more depth in both of these. But just to give you kind of an overview and to help answer some questions and help put some things into context for you, I wanted to just kind of lay it out here for you. So on the publishing side, we're going to ignore the right side of the screen for now. We are just talking about the songs, the things that the lyricists, composers, arrangers, and to some extent, depending on the genre, depending on the creative process, probably the producers as well, were involved in helping shape the song through lyrics and chord progression. So ignore the right side of the screen. If you can block it out with a piece of paper, do that. So on the publishing side, there are 3 very common forms of royalties and license fees that come in. The ones that people have heard of the most are from the PROs, the performing rights organizations. There are 5 of them in the US these days. For a long time, it was only 2, but now we're entering kind of a weird new era of the music industry where everything is splintering and decentralizing. So we have 5 performing rights organizations in the US, and what they do is they collect public performance royalties from songs. So when songs are played on the radio, when they are performed live, when they are played as background music at your doctor's office or in a restaurant, or if it's playing on the PA system at a music venue in between bands, any kind of situation where music is being played in a public way, the composition, but not the recording, is earning a public performance royalty. And so the PROs, ASCAP and BMI, were formed in the early 1900s. They were set up to streamline that process because there are, at this point, millions of songwriters and publishers out there, and tens, if not hundreds of thousands of businesses that use music in some way that involves a public performance. Think of all the radio stations all over the country, every single dentist's office that has some elevator music going on, or soft rock or whatever it might be. It's very complicated to have each of those businesses track down each songwriter and go get a permission license to a public performance from all of them so they can play a playlist, right? So the PROs were created to sort of be the central place where licensees or people who want to use the music can go just pay an annual fee, and they get access to that PRO's entire catalog, and then they can use it however they want. And then the PRO, in turn, collects all those licensing fees and turns around and distributes them to all the songwriters who have signed up with them. So that's one major source of revenue. Most original songwriters are registered with one of these PROs. Their publishers usually are registered with all of them so they can capture all the weird co-writes and things that happen. And they collect money directly from the PROs, from music being streamed, played on the radio, performed live, and all sorts of other things. Then there is a separate royalty. It's also related to the song, not the recording, but just to the song, called the mechanical royalty. And one of the most sort of common areas where this mechanical royalty is generated and earned and collected is in the streaming world, because I have to explain how mechanicals work in order to get to that, actually. Because there is a way in which the songs are being used that triggers a different right. Remember those rights on this list. The PROs are collecting public performance royalties from this right here, but the mechanical royalties are implicating this right. And because copyright is a bundle of all of these things, these rights are separable from each other. So the PROs are out here collecting the public performance royalties, and then the Mechanical Licensing Collective, or the MLC, is doing a very similar thing, but for the mechanical royalties that are generated from streaming. So what a mechanical royalty is, try to keep this very brief, is that every time a recording is copied, the song that's embedded in that recording is also inevitably copied. You can't copy a recording of a song without also making a copy of the song itself in the process. It's a bit of a weird concept, but the publishing industry was very intent on making sure that this was in there when recorded music came about, because they wanted to make sure that they were not losing out on money that would have been earned through hiring a band who would have then bought sheet music for their performance. So they wanted to make sure that they were still being, capturing essentially the same thing when recordings became the way that people consume music. So mechanicals are also earned every time a physical sale is made or every time a digital download is made. Anytime a song is being copied, and what that really means is anytime a recording is being copied, then there's a mechanical royalty being earned on the song. So the publishers, the songwriters, are the ones who are collecting those mechanicals. And don't get it confused with masters. These are two very common terms in the music industry that both start with M and are both referred to in the plural, mechanicals and masters, but they are two very separate things, and they refer to two completely separate copyrights. So I just want to make that point here so you understand. And then what you probably heard a lot about is the world of sync licensing. That's an area where songs are used in connection with a film or a music video or a TV show or commercial or some other form of video. And the use of that music needs to be directly negotiated with the songwriter and or the publisher, whoever owns that musical composition copyright. And it's a very robust area these days. There's lots of content being created that needs music in some way or another. And so sync licensing is happening quite a bit and is starting to make up a pretty significant portion of money earned from catalogs these days, which is part of why we're seeing a lot of catalog sale activity and things like that. And then on the publishing side still, the last point is that because lyrics are covered by the musical composition copyright, there's opportunities to make money from licensing out the lyrics directly through lyric websites, through t-shirts, through other things where lyrics can be used. Generally, that implicates the musical composition copyright and needs to be licensed. So it's another opportunity for revenue streams. And then to the extent that sheet music is still being made, which it is, just not as prominently as it was 100 years ago, there's absolutely, still money to be made on the publishing side from that sheet music. Does not matter what recordings are being involved, because again, you're transcribing composition, not a particular recording. I know that's not entirely accurate, but we'll set that aside. Now, setting that aside and looking at the right side of the screen, there's a whole different set of revenue streams that come in on the masters, the recording side. Every time an album is sold physical or permanent digital download format, or even when the recordings are streamed, you have a copy of the recording being made, you have distribution of recordings happening, and so that implicates some of those rights of the copyright. So because it involves the rights that the copyright owner holds exclusively, they generally need to be paid a fee or a royalty in order for people to do that. So streaming services, record labels, other entities that deal in recordings have figured out a system where those royalties flow back to the ultimate copyright owner through distributors and other channels like that. There's not a general public performance right. So ASCAP and BMI and these other PROs do not collect royalties from recordings. That's not what the PROs do. They only collect on the composition side. So you're not going to see any sort of official PRO for sound recordings because there is no general public performance right. However, because we have that very limited digital public performance right, the streaming services and other places where on-demand use of the recordings is happening pay a fee directly to the distributors that basically covers this digital public performance right that's kind of bundled in with the money that they're paying for the use of the song for streaming purposes, because these are technically two separate sets of rights within that copyright that are being implicated. But then the other place where digital public performance royalties are collected is through non-interactive streaming. So digital radio, satellite radio, internet radio stations, the internet simulcast of Kubo or other radio stations that have an online broadcast, those all implicate a non-interactive digital stream. And so there is a sort of a PRO for that called Sound Exchange. So Sound Exchange does not capture all of the digital public performance rights, but only the ones that come from non-interactive streaming of sound recordings. So if your music is being played on a digital radio station or a satellite radio station somewhere, you're going to see money come in on the publishing side if you're the songwriter, and then you will also see money come in through Sound Exchange because you're implicating that digital public performance right. So you can go and sign up with Sound Exchange and claim the royalties that have come in from your recordings through that. And then the sound recording counterpart to sync licensing is called master use licenses. And these days, these are sort of commonly bundled together, especially when the songwriter is also the artist or they're independent and they own all their own rights. But regardless, you're still dealing with two separate copyrights. So it's technically a separate license to use the recording. So if you're a filmmaker, I know I saw at least one person in the comments here talk about being a filmmaker and looking to understand more about the music industry. It's important to understand that licensing the recording and licensing the song are two separate things. So what I always recommend to people is to license the song first, because you cannot do anything with a recording if you don't have the rights to use the underlying song. They're two separate copyrights, so it does not matter that you have the rights to a recording because you still need to get permission to use that underlying song. So it's kind of a weird, complicated relationship between recordings and compositions. But it's important to understand that in many cases, especially if you're dealing with a major, well-known song, well-known recording, you're likely going to have to clear the use of the recording from one company, usually the record label, and go to a completely separate company to clear the rights to the underlying song. So in some cases, filmmakers can get around this by licensing the song and then finding a local band's, lesser known cover of it, or even just a generally lesser known cover of it, or even hiring their own musicians to perform the song. Or in the case of one of my clients, they actually had the actors singing the song as part of one of the scenes. And in those situations, you're not using anybody's existing recording, so you don't need to go and get the rights to that recording. You do need to get the rights to the song, right? So they're two separate things. But if you're the one who owns those recordings, then this is a revenue opportunity for you, right? You can get a license fee for the use of the master, the recording, and a separate license fee for the use of the song. So if you're a songwriter who also owns your own masters, you have the opportunity to earn revenue from both of these things. So with that sort of background all in mind, there's a really important concept in copyright law that involves collaboration. And this is where copyrights are co-owned. Now, the first really important thing to understand, which I mentioned earlier, is that if you collaborate with somebody and you do not have a contract, these default rules from the copyright statute will kick in, and they will control legally what people's rights are and what they're able to do with the copyrighted work, unless you use a contract to change it. So this comes up all the time in the music industry. It comes up a lot in the film industry as well. In fact, all the entertainment industries use contracts so extensively because of this co-ownership issue. The way the copyright law is set up with its default rules is not beneficial to any one in particular co-owner, but instead gives more or less equal rights to all co-owners. And so even though that is the fair and equitable thing to do when the parties have not agreed to something otherwise, it's not usually the reality of how the parties want it to be handled, right? So even though you might be collaborating with other people, you might still be the one who's kind of lead on the project, or it might be under your name, or it might be your company is paying for everything. But it's important to understand that the only way that you can change some of these default provisions is by using a contract. So this is why we have split sheets and session musician agreements and record deals and publishing deals, because if you are dealing with copyrights and you don't have a contract, especially if there's money involved, there's a lot of misunderstanding and miscommunication that can happen around co-ownership specifically. So with that being said, let's talk about what these default rules are. The first one is that the co-authors are automatically co-owners with equal proportional shares of ownership. So if I co-own a house with somebody, we own it 50-50 unless we have a contract that says otherwise. Same with copyrights, right? Now, more importantly, what stems from this is that even with your 50% share or 25% share or whatever it might be, let's say I only own a 1/4 interest in a house with, let's say I have 3 siblings and we co-own this house together. I don't have to confine myself to just 1/4 of the house. I can use the whole house because I am one of the co-owners. Same with copyrights. So if you are a co-owner of a copyright, you are entitled to use and commercialize the entire copyright, generally without the requirement that you get your other co-owners to sign off on that or get their permission. Now, the exception to that is if you're getting into any sort of exclusive deals. So if you're trying to give a third party some sort of exclusive control over your copyright, then you do need to get the other co-owners to sign off on that. But for anything short of that, so any type of standard sync license is typically non-exclusive. Any type of streaming distribution deal is typically non-exclusive. Many agent type relationships tend to be non-exclusive these days because nobody really wants to invest too heavily in just one person and get the exclusive rights. So a lot of deals out there are non-exclusive, meaning co-owners of a copyright can generally go out and do things with that copyright and get into these types of licenses without their co-owners involved. The only requirement they have in that situation is that they need to pay their co-owners proportional shares of the money that comes in. So if you co-own something with 3 other people, then they are each entitled to 25% of whatever money you bring in from that. Sometimes that is not the situation that people want, right? So a band leader hiring musicians or maybe a famous songwriter who's hiring some lesser known songwriters to help on a co-write situation. The goals and the objectives of the people involved might be that one person comes out of that with exclusive control over that song or over that recording. But the only way to accomplish that is to use a contract. No matter whether money has changed hands or you've talked verbally about, yeah, this is my song, I'm going to do something with it, I'm going to be the one to take it to my publisher, etc. Does not matter. Copyright does not recognize transfers or changes in ownership of a copyright unless they are in writing. So this is why contracts become so important in the music industry, because collaboration is happening all the time. And usually one or two people from that project want to be sort of the primary people in control of it. And the way to do that is to make sure your collaborators are signing off on a clause that actually transfers their copyright ownership. Now, there's another important default rule to understand, and this is another reason why contracts become so important, but this is a rule that cannot be changed by contract, which is that co-owners, because they are all legally owners of the copyright, cannot sue each other for infringement. Because if one of them uses the copyright, they are still the lawful owner of that copyright doing something with property that they own. So they cannot be sued for infringement just because one of the other co-owners doesn't like what they're doing. What you can do is get into a contract with your co-owners, and you can say, you're not allowed to do X, Y, and Z with the copyright. And then if they go and do it anyway, now you have a contract action you can bring against them. You still have some sort of recourse, but you're not going to be able to bring an infringement claim against them. You can bring an infringement claim against third parties who are not owners of the copyright, but are using it without permission. But that's a different situation, right? So you can still, like I said, use a contract amongst yourselves as co-owners to sort of regulate each other and decide what the rules will be. But it's important to understand that the only legal recourse that you typically have in the absence of a contract is to get some of your money from the other co-owner, but you're not really going to be able to do much to stop them. So that's why we use session musician agreements and other types of contracts to really try to consolidate and control and limit who from a collaborative project actually has ownership and control over the copyrighted work. So since we're now talking about contracts, let's talk about what exactly a contract is. So very simply, all a contract really is a promise that the legal system will enforce. So once two or more people voluntarily agree to put themselves into a contractual agreement, the law is willing to step in and recognize that agreement and provide both of those parties with tools to be able to enforce that agreement. So from a very, very basic contract law standpoint, a contract can be formed verbally or in really any type of writing, or even without a writing or a conversation if it's implied by the party's conduct. So classic example of the implied contract would be some sort of offer is made and then someone takes action in accordance with that offer. So I tell somebody, hey, anytime you're free, you want to come by and paint my house, I'll pay you $500. The person never responds to me, but 2 weeks later, they show up and start painting my house. That is enough to show that there's been an implied contract because there's a promise that was made and that person accepted that offer and followed through on that promise. Now, what's important to understand is that contracts generally cannot be one-sided. There needs to be some sort of exchange between the parties. Usually it's money, but it does not have to be. And it just has to be something that reflects that the parties have voluntarily agreed to give up either some money or some of their free time or a specific service that they offer in exchange for another service or product or money or something from the other side. There's a bargain being made, and that's what's consideration. So it's kind of a complicated term. It literally takes months in law school to work through and understand what that means on a deep level. But what's important for you to understand here is that as long as there are three basic elements, that there's been an offer, an acceptance of that offer, meaning there's what we call meeting of the minds. So all parties are aware of the same terms that they're agreeing to, and that there's some sort of bargain being made. So I didn't have to give up this $500, but I am voluntarily giving up the $500 because I want this person to paint my house. They don't have to paint my house. They're under no pre-existing legal obligation to paint my house, but they are voluntarily giving up a couple hours of their time to do that in exchange for this money that I'm offering. So as long as you have that there, you have a binding contract. So it can be exchange of emails, text messages, it can be a verbal conversation. But the reason we need something in writing is because writing is the best evidence of the agreement. When you put something into writing, you are being clear and specific about what those terms are, and you're putting it in a form that can be referred back to later. So again, it can still be in an exchange of emails or text messages that counts as a writing, but by putting it into one cohesive contract document, you kind of put everything in one place and make it easy to refer back to later. And essentially what you've done is you've created a set of private laws between you and the other party or parties to the contract. And so, in the process of putting contracts together, using contracts as part of a regular business practice, you really create stability and an ability to have a good, solid workflow for really any type of business. And it's especially important in the entertainment industry because of all these weird rules about copyright that dictate what you can and can't do, what happens with co-owners, and things like that. So really crucial to the management and operation of an entertainment company, whether it be a band or a label or a publisher, or even a studio, a producer. They're dealing with copyrights on a regular basis, and contracts help you control what happens to the ownership, what happens to the flow of money, things like that. So broadly speaking, I like to put contracts into two general categories. There's a whole world of contracts that you're typically dealing with before a project starts. And then there's a separate world of contracts that you're dealing with after the work exists. So on the front end, if you're working with collaborators, you're usually going to be looking at things like split sheets, session musician agreements, producer agreements, engineer agreements. And if you're part of a band, you might have a band agreement in the form of a partnership agreement or an LLC operating agreement, or something similar to that. And what you're typically doing in those contracts is setting out the terms ahead of time of copyright ownership in this collaborative project that you're about to embark on. And usually that goes hand in hand with a discussion and an agreement on compensation, whether that be upfront money or back-end royalties or a mix of both, and also a transfer of copyright ownership in many cases, because usually what's happening is that we're consolidating copyright ownership into one or a small number of people or entities that own the copyright once the project is actually complete. So by putting these contracts in place ahead of time, everybody's going into it with clear understandings of what these terms are. If you go to a town like Nashville where there's a lot of session work happening, all these session musician agreements know that the basic typical thing you do going into a session is you learn the parts, you play, you do a couple takes, and in order to get your money at the end of the day, you sign a session musician agreement where you give up your proportional share of copyright ownership. Pretty standard thing in the music industry, but a lot of people who are independent artists who are not operating in these sort of more established, structured systems within the music industry in New York, Nashville, and LA are kind of figuring this stuff out for themselves and having to sort of structure this stuff for themselves rather than having a label or somebody else come along and dictate how it needs to be done. So you've got all this stuff on the front end. And then once the work exists, now you're going to take it out in the world and you're going to either license it directly for sync or master use, or you're going to work with a distributor to get it up on streaming, or you're going to partner with a record label and or a publisher. And so the types of agreements and sometimes the clauses that are contained within larger agreements are typically in the form of what we call a license, which is a situation where you retain ownership of the copyright and give someone permission in some sort of limited way, or an assignment where you are outright selling the copyright to a third party. So a record deal, especially the old school record deals, usually involve an assignment of the sound recordings from the recording artist to the record label, right? That's what you do after you finish the session, is you transfer that ownership to the label, who then takes the masters, turns it into a record, manufactures copies, sends it out to the stores, things like that, right? License agreements allow the copyright owner to retain ownership, but usually are embedded within other types of contracts. So sync license is primarily a license, but a more modern record deal will be in the form of an exclusive license instead of an assignment. So you retain ownership of your masters, but you're still giving the label permission and control over the work for a specific amount of time. So you've got these two broad categories. So it's important to understand that there are a lot of different points in this process, and we're going to work through this in, I believe, week 4 or week 5, kind of tracing through the steps and the points at which these different contracts come up. But it's not just, hey, let's do all this stuff and then wait till the very end to get all the contracts in place. There's times throughout the creative process where contracts become important, and it doesn't all need to happen at one particular time. It just depends on what exactly you're doing in terms of creating a work or taking an existing work and doing something with it. And yeah, like I said, we're gonna dive into that in more detail in a later session. So when you are putting contracts together, the two biggest points that I want to impart upon you are the two highlighted things at the top. A lot of people don't take the time to look at the weird ambiguities or inconsistencies in a document and make sure to address those. Sometimes it'll say, oh, you're transferring all your rights to us. Well, that's not really a very specific term, right? And so what I'll often do in those situations is say, let's break this out a little bit more. Let's make it clear that this person is transferring their claim of sound recording copyright ownership to this other person. They are also transferring their musical composition ownership to this other person. So having ambiguities is where you see miscommunications and misunderstandings. Some people remember the same situation in very different ways. And so whenever there is ambiguity in the actual document that makes up the authoritative contract, that's where you potentially get into lawsuit territory. So again, by focusing on the front end, getting the language clear up front, you help avoid the possibility of lawsuits later on. Of course, somebody could always go crazy and file something anyway, but if you have clear terms, then nobody is misunderstanding things later, right? At least that's the theory. The other thing that I commonly see is that people will have a contract put in front of them and then assume that they have to sign it as is. And even if what we're asking for is super minor, I always tell people, look, if you don't ask for this, it's not going to happen, right? And so don't be afraid to say, you know what, my name is misspelled here, or I need there to be a credit provision here so that I'm actually, have my name in the liner notes, right? If you're not asking for it, the other side is not usually going to voluntarily give it to you. So even if it's something really small, it's absolutely worth bringing up. And in situations where you have, good bargaining power and it's a bigger issue, it's absolutely worth addressing, because the worst that can happen in most situations is that they say no, and then you just go back to the drawing board. Absolute worst situation is that it freaks them out that you're even trying to negotiate and they destroy the whole deal. But in my mind, that's a red flag and somebody you're better off not being in a deal with anyway. But in any event, just want to highlight that point for you. So when you're working through most music contracts, you're typically going to be looking at a lot of sort of common broad categories of things that need to be addressed. These can take different forms depending on the specific contract, but usually you have some sort of service being provided or some sort of project where there's a deliverable being made that will be completed by the end of the contract or as part of the performance of the contract. There will also almost always be some sort of compensation. Keep in mind that compensation takes many different forms in the music industry. So just because something is in a back-end royalty format does not necessarily mean that there is a shared copyright ownership, right? So copyright ownership and royalties are two completely separate things. Royalties are just a form of compensation. They're very commonly used in the music industry. And so people do tend to conflate those two things. And this is an area where there's sometimes not a lot of clarity in the agreement. Again, this is something where I like to really make sure this is broken down and say, we're going to address copyright ownership, and then we're separately going to address compensation. And then if there's any sort of credits or you're going to add my writer to the ASCAP work registration as like a bonus or something like that, then we will address that separately. But simply saying in a contract, I'm going to give you 5% doesn't really tell you what you need to know. You need to know who owns the copyrights because you need to determine whether you are a co-owner with this other person or not. And in most cases, co-ownership is not the situation that people want. So worth addressing on its own, the copyright ownership scenario. And then even if you are not a copyright owner or getting paid a flat fee up front and not getting any sort of back-end royalties, it's usually a good idea to make sure there's some sort of credit provision in there so that you are still being listed as the engineer or the producer or the bassist or the backing vocalist or something like that, because credits are a really important way that people find you for future work. They really like what you did on so-and-so's album. They want to hire you for their next album. But if your name's not there in the credits and they have no way of finding you, then yeah, maybe you were involved in that project, but you're not really getting any longer term benefit from that, right? So important to address that in the contract up front so that you know you're getting a contractual agreement from another person to actually put your name in the credits. Depending on what type of contract it is, you might also be dealing with deadlines. And then, commonly overlooked thing, especially with contracts that people are drafting for themselves without an attorney, are all the boilerplate, the fine print, the stuff that nobody wants to read. That is where all the important dispute resolution terms of an agreement are typically found. So when we're talking about choosing what court to litigate this in, whether we have to go to arbitration or mediation first before going to court, who's going to pay the costs, are we shifting attorney's fees based on who wins and who loses? Those are really important things that have a pretty significant impact on whether it's on your decision as to whether it's worth suing or whether it's worth, going after somebody for something. And if you do choose to do that, it gives you a guideline as to how to do that. So boilerplate can be a really important thing that actually helps in many ways avoid or at least minimize the conflict that might come up when there's a disagreement. If you have a disagreement, that's going to happen. But if you have a very clear method or procedure for handling that, then it doesn't add fuel to the fire and make it a more difficult situation to untangle, right? So boilerplate, frequently overlooked, but definitely an important thing to include. So let's touch on AI for a second here. There's really two sides of the AI coin, as you probably know by now. On the output side, we're talking about the creations of AI tools, right? So when you're using a generative AI tool in music, we've got at least 2 or 3 big ones out there, and 2 of those are being sued in federal court right now. there is a long-standing requirement in copyright law that we have human authorship. And so if something that is purely AI generated is not generally going to have copyright eligibility in the first place because it doesn't have that first element of human authorship. Yes, it may be fixed in a tangible medium of expression, but it's not a human who authored that expression. So in the Copyright Office's eyes, that is not something that can be registered for copyright because it is not eligible for copyright in the first place. Now, the Copyright Office has taken a pretty nuanced look at this and just about a month ago released a report on its stance on copyright eligibility for AI-assisted and AI-generated work. And where they essentially drew the line is where you can show that the final expression is the product of human authorship, then you can get a copyright in that. So if you're using AI tools, that the human still needs to be involved in that creative process that leads to that expression. So simply entering prompts is not going to be enough because the expression is the output, not the prompts, right? So it's kind of a close call. It's a little bit of a fuzzy thing, but the point is, the bottom line here is that the Copyright Office and our copyright system is recognizing copyright eligibility for AI-assisted things, and especially things where AI was used as like a processing tool. It isn't really involved in the actual creative expression that is being made, like an AI tool to help with mastering, for example. Those are situations where copyright is not in question, and the human who created the work will generally be considered the owner of that copyright. But if it's something where the AI tool actually generated that expression, so you just entered some prompts and it created a piece of music for you without you really doing anything to that piece of music once it came out, that is not something that is going to be recognized as having copyright at all. So by not being eligible, it means that it is immediately public domain. So most of the stuff that Suno and Udio are pumping out based on people's prompts, at least that initial output is not protectable as a copyrighted sound recording or a musical composition. Neither of those copyrights is involved. But if you take Suno and you spit something out and then you take that output and continue to work with it and create something from that, now you have a human authorship in that final expression. Whatever that finished product is will have human authorship in it, and the Copyright Office is willing to recognize a copyright in that. So the best example that I can think of off the top of my head is you could use Suno to create a particular output, and maybe you need to keep reworking the prompts to sort of refine it a bit. But once you get that output, now you have a song. So maybe the composition is public domain because it was AI generated, but you can take that song and now you can go and re-record that whole thing, and now you've got a recognizable human authorship in the expression of that new recording. And so you can have a human created, human owned sound recording copyright, even if the work started as an AI generated thing. You may not necessarily have a musical composition copyright in that example I just gave, but you conceivably could use that to create records and at least own the rights on the recording side. Now, on the input side of things, and this is where a lot of lawsuits are happening, all these AI tools are ingesting data in order to train their large learning models. And many of these AI companies completely disregarded copyright law when they were doing this and scraped all kinds of data from all over the internet and all sorts of things. And we've got generative AI tools in creating literary works, creating audiovisual works, creating songs, creating video, poems, all sorts of things, right? So they're pulling data from all this stuff. And arguably, it's a commercial use, right? They're taking existing copyrighted material, they're processing it in certain ways, using it to create a tool which they then charge people money for, and it delivers these outputs that essentially are the entire value of using those tools in the first place, right? So there are approximately 40 federal copyright infringement lawsuits going on all over the country against various different AI companies, specifically involving copyright infringement claims. Some of them involve music, some of them involve newspaper articles. It's kind of a wide range of things because generative AI tools are squarely targeting human expressive content, right? Or typically human expressive content. So it's sort of directly at odds with copyright ownership. And what a lot of these companies are trying to argue is that this training and processing should count as a fair use. And that's a whole complicated thing that I don't have time for tonight. But the argument basically is that they are transforming the purpose and character of this material and turning out something that's completely different. The problem that they're running into is that a lot of the outputs tend to sound almost identical in some cases to existing works, especially if you're specific enough with the prompts that are used. So it's still an ongoing fight, and definitely a lot of nuance to it. But the bottom line is that we still don't really have a definitive answer on whether this type of activity is technically infringement. Recent decisions from a couple of courts are starting to show that it probably is infringement. So we probably will, and in fact, we are already seeing more licensing going on where companies are actually paying for access to this data. And it will not be long before you start seeing that pretty consistently in music, whether it's your distributor or your label or your publisher or somebody else coming along saying, you know, hey, are you open to licensing your material for such and such a purpose? So definitely something interesting to think about and talk about, but it's also very much in flux. So a lot still to be seen in that world. So that's about all I have. Here's some resources if you're looking for additional information or you want to go a little bit more in detail, in depth with some of the stuff we talked about tonight. I'd definitely recommend Songtrust and TuneCore's blogs for some good articles that explain different types of music royalties. Stanford University has a great website all about fair use that explains how fair use works, and provides all kinds of examples and real cases that help illustrate the ways that judges make decisions about that. And then the US Copyright Office provides some really helpful documents called circulars that are generally between 3 and 5 pages each. They're PDF documents that you can download that touch on very specific topics involving registration and other things with copyright eligibility. And because they're short, they're very kind of bite-sized and focused on specific things. So there are 70 or 80 circulars up there on their website, but you can read through, you know, one at a time or focus just on the one question that you need answered. And usually the circulars do a really good job of addressing the most common questions that come up around copyright, especially registration. And then I really like Ari Herstand's blog called Ari's Take. He's a music industry consultant and knows about all the different royalties and streaming platforms and how all this stuff ties together. So highly recommended resource. And then of course, you can always reach out to me or it's Dave Ratner, who's gonna be presenting next week, and send me any follow-up questions or schedule a consultation. There are also several other music attorneys here in Colorado. At least 2 of them I saw in the chat are in attendance here tonight. And there's a couple others that I know of who I don't believe are here tonight. And there's also entertainment attorneys all over the country, and these issues are not very state specific. So if you have questions, we're definitely a good resource for this stuff because it's really important that artists understand how these rights work. It's how you make money. If that wasn't clear already from this workshop, that's really the fundamental underpinning of value in the music and entertainment industries is how you control and manage copyrights, especially through contracts. So with that, I know I didn't leave a ton of time, but I'm happy to stay on for a bit and answer some questions. So I don't know if Meredith, you want to start with like the oldest thing in the chat first, or maybe some of these have already been answered. And maybe some of these are not even questions. So
yeah, most of the chat is just gratitude. Thank you so much, Max. You really you covered a lot, and a lot that we will be revisiting in further depth. So this was just a great foundational presentation and sort of sampler platter. If there are any questions, this is your time.
Yeah, and feel free to, if you're able to, come off mute and just ask your question verbally. So I frequently find that questions you have are questions that other people probably have as well. So it's useful for everyone's edification to get certain things addressed in a group setting. But also we have 5 more sessions. So there's going to be a lot of opportunity to dig into this stuff in more detail and ask questions at a later time. So if there are none tonight, that's also totally fine.
Oh yeah, link for future sessions. Maybe Marshall can help me and put that in the chat. So yeah, there are 5 more coming every Monday night now through April 7th, I think is the last one. So I know our next session is March 10th, talking about publishing. So diving deeper into PROs and publishing. And then after that, March 17th, I think we're talking about masters. So these are all open, they're free. You can sign up for one or all of the sessions. And we also, as you've noticed, have been recording tonight. So these recordings will also become available to those that have signed up. Oops. There we go. Thank you, Marshall.
Max, I have a question for you.
Yeah.
So you know the MLC is a new kid on the block or whatever, right? So
Yeah.
I'm curious about what specific space they occupy right now, because I know that so your PRO will collect your royalties for your public performance, and then like your distribution company will collect a royalty for mechanicals. So what is the MLC's job? Are they also collecting like black box funds? Like what space do they occupy?
So, big picture, mechanical royalties are one of the weirder areas of revenue in the music industry that are related to your songs. So your original songs, lyrics, compositions that you wrote, not connected to your recordings in terms of a legal direct link between your recordings and your mechanicals, but sort of indirectly connected to your recordings in a weird way. So the reason that we even have this concept of mechanicals in the music industry is because publishing came first, right? Before we had recording technology, we had music and we had musicians, right? We had people writing songs, writing sheet music, writing lyrics, all sorts of things. And once recorded technology came along in the 1910, a little bit before 1910s, and then became really widespread in the 1920s, 1930s, the publishing industry wanted to make sure that they were still capturing some sort of money even when records were being made of songs. And the reason for that is that every time a song was being performed before recordings were made, you had to have a live musician there actually playing the song. So once live musicians started being replaced by recordings, the publishing industry said, hold on a second, we want a piece of this. And so they created this concept called mechanical royalties, which means that every time, and this is a bit of an outdated term, but every time a mechanical reproduction of a song is made, that the publisher should get a piece of that. So what that means for practical purposes is that you have this song, this musical composition, there's a copyright for that. And in order for somebody to record that, there's a couple things that need to happen. The first thing is that the owner of the song, the songwriter and or the publisher, needs to give permission for that song to be recorded. So that's called the first use license, first use mechanical license. So classic example in the music industry, if you are a songwriter who is also a recording artist and you sign to a record deal, you are typically bringing that record label a bunch of songs that have never been recorded before, right? That's part of the value, is they want to be the ones to exclusively put out your new batch of songs. So you as the songwriter have to grant the label permission to do that and permission to release those songs in the form of recordings out there in the world. So as the dual songwriter recording artist, you're wearing both hats. You sign on as an artist, and there's a bunch of clauses in your 40-page record deal that deal with being an artist. But then there's one or two clauses that address your role as the songwriter, one of which involves you granting this first use mechanical license to your record label. And what that means is that you are giving the label permission to record your songs for the very first time and commercially release them for the very first time. And so in order for the label to be able to do that, they have to get this license in place. And then every time they do a run of 10,000 CDs or 1,000 vinyl or whatever it might be, they are making copies not only of your recording, but also of your song. And that's called a mechanical royalty, because every time the song is copied, the songwriter and publisher need to get paid on that. So before the internet, before streaming, the only place where mechanical royalties were really coming up was in this record deal situation. Recording artists were recording their own original songs, giving labels the mechanical license to record and release those songs, and then they get paid a royalty as an artist called the artist royalty. And then separately, because they are the songwriter, they get paid a mechanical royalty. Two separate forms of money. One is directly related to the recording. That's the artist royalty. The other is directly related to the song. Two separate copyrights, two separate royalties. But because you are both the songwriter and the artist, you're receiving both of them. So the other situation where mechanicals come up, again, we're talking pre-internet, just to be very simple here for a second, is with covers. Once you have granted permission for your song to be recorded and released commercially for the first time, there's a special provision of the copyright law called the compulsory mechanical license, which means that once a song has been released commercially the first time, anybody else can come along and record their own version of that song without needing to get permission from the copyright owner. And in this case, the copyright owner is whoever owns the song. Does not matter who made the first recording. What matters is who owns the rights to that musical composition. And once that first recording has been put out there in the world, anybody else can come along and make their own recording. So in order to make sure that songwriters and publishers were paid for that, the artists, and in some cases their labels, if they were signed to a label, would have to then pay the mechanical royalty from their album sales to the songwriter, who in this case is not the recording artist. But in every situation, the mechanical royalties are always going back to the songwriter and their publisher, because just the way that recording technology works, you cannot copy a recording without also copying the song. So when streaming came along, the streaming services, just the way that the technology was developed, are set up in such a way to minimize buffering and slowdowns and lagging and things like that, which anybody who was around in the early days of the internet remembers that not very fondly. To get around that, what they do is, instead of truly streaming a file from their server, which will require an incredible amount of processing power and server space, especially as you scale up your listeners. They instead deliver a copy of the song and recording to your computer where it lives temporarily and then gets deleted. And that's called an ephemeral copy because it only lasts for a short amount of time. And so because this is what's going on in the background technology of a streaming service, Congress and all the other interested players in the music industry said, hey, hold on a second. This is involving copies, just like physical album sales, just like permanent digital downloads. You are making a copy of the song every time you are making a copy of the recording. Therefore, a mechanical royalty is owed for every copy that is made. So with every stream on a streaming service, there is an ephemeral copy of the song being made and sent to the listener's computer. For the first 8 to 10 years of streaming, there was no unified system to collect those mechanical royalties. So the streaming services went to the Copyright Office and they filed these documents called a notice of intent to pay, saying, hey, we've streamed all these songs, but we do not know who the copyright owners are because a lot of people out there have music up on the internet, but don't have it registered with the Copyright Office. So these streaming services were seeing all these play counts go up for all these various different songs and recordings. They wanted to pay the proper rights holders, the songwriters and their publishers, but they had no idea who they were. So the Copyright Office was flooded with hundreds of thousands of these documents. And if you were a songwriter, you could actually go in there and try to find your stuff and claim it and make sure that you had your copyrights registered and your ISRC codes and other things to match up so that the streamers would actually pay you your mechanicals. And then companies like Songtrust came along to help people capture some of these more difficult royalties to capture. And that is what they mean by black box money, is the stuff that sort of is being generated because it is a legal obligation under copyright law that if you are copying songs, copying recordings, that you are basically accruing royalties that need to be paid to those copyright owners, but you have nowhere to send the money. So it just sits there, right? So in 2018, Congress passed the Music Modernization Act, and it created, amongst other things, it created the Mechanical Licensing Collective, which is essentially built to be very much like a PRO in the sense that you have all these various streaming services that are piling up royalties, but they don't know who to pay and they don't want to go through the process of sending out individual payments to millions of different songwriters. And they just pay into the MLC instead. So then songwriters and publishers go sign up with the MLC. Their music is probably already out there on streaming because they're working with TuneCore or DistroKid or another distributor to get their music out there. But because they are not signed up with the MLC yet, they're not getting that particular stream of revenue. So when you sign up with the MLC as a songwriter, or if you have a publisher, then they're the ones going and doing this for you. Then what you're claiming is the mechanical royalties that are derived from this background technology involved in streaming. So that is one revenue stream out of many that are all coming out of play counts that are happening on streaming.
Got you. So the MLC and your distribution company are
two separate things.
They're not going after the same mechanical royalties.
In most cases, that's correct. Most situations, your distributor is only dealing with your masters, the recordings, and not your compositions.
Gotcha.
So the masters, there is a royalty that's generated from streaming, from physical sales, from permanent digital downloads, and your distributor is getting paid a portion of that money directly from the streaming services. But then from those same streams, the streaming service is paying a slice of that to the PROs for the publishing, the performing rights, public performance royalty. They're paying another slice of that to the MLC that also goes back to the publishers for the mechanical royalty. They're paying a slice to your distributor, and they're paying a slice to Sound Exchange if there's any non-interactive streaming going on. So all of this flows. If your music is on streaming, is on Bandcamp, is out there for distribution, it's already generating at least 3 separate revenue streams that are already being collected by somebody somewhere. And if you are both the songwriter and the recording artist, then you can go and claim all of those.
Thank you, Max. And we are well over time, but I think like if folks want to hang around and ask some more questions, if you're okay with that. I do also, and I see this relates to one of the questions in the chat, a lot of this, like the entire session next week is all about publishing. So we're going to revisit this and go even deeper. So I also find Max to be like, come back next week. It looks like, is it Smokey who also had a question? I saw that one next. If you want to
Y'all hear me?
share that. Yeah.
All right, cool. So, my question is sort of like specific, but I'll generalize it just to not take too much of your time. But so I bought a beat from a producer, and we talked about like some royalty splits. He says that he wants to go 80-20 on the mechanical royalties, and then he wants to go 50-50 on the publishing. So my question is, why would he want to go 80-20 on the mechanical royalties, but 50-50 on the publishing? Like, what incentive does that create exactly?
So my best guess is that he is dealing with a very common issue in the music industry that I've seen who knows how many times, which is that he's using mechanical to refer to masters. They are 2 different terms that get mixed up all the time.
That's what I thought too.
He's probably talking 80-20 on the master and 50-50 on the publishing would be my best guess. He probably needs to come to these classes, so send him the link. It's totally free, so what harm is there? And usually what people mean when they're proposing different splits on each side is a reflection of what they see as each person's contribution, right?
Mm-hmm.
So if, let's say, and these are fairly common numbers that I've heard people talk about before.
Right.
Usually when people collaborate on the song, unless somebody did just a tiny little piece, the common practice in the industry is to split the song, the publishing.
Mm-hmm.
Terms are used interchangeably, but they mean the same thing. When they talk about splitting the publishing, most people split that equally. Unless it's a situation where it's like one person wrote the whole song and then you came in and just wrote one verse or just wrote the bridge or something like that, maybe they would propose a different split. But again, that's just on the publishing side. And then on the recording side, people tend to get a little stingier with the way they divide up percentages on the map recording side. For instance, if you, let's say you're doing like a rock record and a band walks into the studio and the publisher and the producer is there to help produce the record, but he's not like creating any of the instrumental tracks or anything like that. He's not recording on the record. In that situation, kind of the typical like rock producer type deal is that they only get like 3 to 5% on the recording. And then the band basically gets the rest, and then the band immediately turns around, and actually the band and producer turn around and sell everything to the label anyway, and the label ends up owning.
Right. And do you think for like this situation, like bringing up like a different like form of like splits, would it be like, let's say I like the beat, but there's things that I want to change within it because it feels like very looped. So let's say like I want to rearrange the composition that he already introduced. And I want to bring in like session musicians and things like that. What do you think, like, what could be proposed to that producer in that sense? What do you think?
So in that kind of situation, and I definitely see this a lot, there is a distinction between buying a pre-existing track and then adding something to it.
Mm-hmm.
That's a derivative work scenario
Okay.
versus going into the studio and creating from something from scratch together.
Mm-hmm.
That's going to be a situation that's treated as more of a collaborative co-authorship and co-ownership situation. So technically speaking, when you're in the first scenario where you're buying an existing track, the only things you can do with that track are what the copyright owner gives you permission to do. So you have to go back to them and say, hey, does my license from you allow me to modify this recording? Does it allow me to take this sort of starting point for a song that you've created and go create my own recording from it?
Right.
Because it's somebody else's pre-existing instrumental track, you have to go through that process. And now it sounds to me, just based on the terminology that this producer used, and no shade, this is very common, this happens all the time.
Yeah.
You might not necessarily understand this stuff well enough to be able to really know what you're talking about, which again,
Right.
why you should also come to these workshops.
Right. That's why I thought of like introducing like some type of like paperwork where it's like, look, like these are the permissions that I'm allowed to, so I can change it creatively, and you can like be a co-owner as well, and then kind of like introduce that because yeah, I am like not just using the beat that he looped and sent to me.
Yeah. So it kind of goes back to this slide that I was talking about earlier, which is in this contract, being very clear about what that scope of work is really important. What are you actually allowed to do with this thing that you are either buying or licensing from this other person? So once you get clarity on that, separately address how payment should be handled. A lot of times people muddy the waters by trying to talk about everything all at once. But if you
Right.
get one piece at a time, you can get a pretty clear picture of what you are and are not allowed to do and what you need to pay for that. And hopefully you can get something worked out. And if you still need help, I'm happy to help put a deal like that together. So
Okay, that definitely clarifies like a lot. So thank you.
great. Yeah.
Thank
So I
you.
see there's another question in the chat that sort of ties back with DNA's question. So the bottom line is, if you have a distributor, you're signed up with a PRO, you're signed up with the MLC, and you're signed up with Sound Exchange, you'll be capturing most of the common, what I call passive royalties coming in from streaming and other common places where your music is being played. Now, there are other things out there where there's opportunities to make more money from your music, music reports, and a couple other things. And working with companies like Songtrust or a publishing administrator can sometimes help you capture some other royalties that are a little harder to track down and capture on your own. But the four big ones are distribution, PRO, MLC, and Sound Exchange. And if you have those and your music out there already, you'll at least be capturing all of those royalties that are potentially already accruing and coming in, just not being paid out. But it also, the other benefit is that by being registered with all those things, it's putting your contact information and ownership information out there in a way that the rest of the music industry is able to find and access, which makes it easier for them to find you if they want to get a sync license or something like that. So I hope that answers D-Trade's question too.
No, that was great. Thank you so much, enhancing
Yeah.
your footprint. So yeah, great, fantastic answer. Thank you so much.
I love it. Excellent question. I think I'm gonna wrap us up. Thank you so much, Max.
Yeah, totally.
I am like so jazzed for the rest of this session and going deeper and revisiting some of these concepts. So thank you for your time and energy this evening, and we'll close out the Zoom. The recording will be available to those that have registered. And yeah, we'll see you next week.
Thanks. Looking forward to it. Bye, everyone.
Thanks, everyone.